Thank you all very much, and I also appreciate you all taking some time out of your very busy schedules to come and meet with us this afternoon. And I certainly must have done something wrong because I have to follow Faith Gay in her presentation and her comments today. Just tell you a little bit about what my practice has been for the last 25 or so years. I've done almost exclusively products liability and mass torts, and when we talk about mass torts, that's really just an aggregation of cases. Also done class action work, but essentially when multiple personal injury cases typically are filed, we refer to them as mass torts. And I've done that in connection with building products, with pharmaceutical and medical device companies, with agricultural companies and products, with respect to computer and software products, consumer products, everything from hair dryers to certain other products that are used in households every day, over-the-counter medicines and things that you can buy in a pharmacy or drugstore. We've also handled environmental issues, including toxic exposures. Also have dealt with, in a personal injury context, exposures to things like radon or lead paint or radiation in various different venues, as well as the automobile industry and probably several others. And Ms. Gay and Mr. Goldstein referred to MDLs, and I guess in the last decade or so, I've served as lead counsel in about 7 or 8 MDLs in the U.S. and currently do that in about 5 of them. So with that brief introduction, what I thought I would try and do in my 40 or so minutes allotted is to provide you with an overview of the way that the plaintiffs actually apply in the real world some of these theories and some of these causes of action, and try and give a little bit of insight and hopefully some practical guidance about what can be expected and maybe some real world examples. The plaintiffs' bar, as you've heard, is very well funded. They are very cohesive. They have learned a lot over the last number of decades, largely from these very large litigations, tobacco, asbestos, certain of the other automobile litigations. And as Ms. Gay said, they've kind of pooled their money and pooled their knowledge in order to target certain industries. But unlike what I think many companies and many defense side lawyers typically think in the way we view how we practice, they're not industry specialists, right? So in other words, typically a company will say, I have a problem with respect to a particular industry, and I'm going to go to somebody who knows my industry. That's not really how the plaintiffs divide themselves up. What they essentially do is they have a playbook, they have a rule book, they have a game book, and they have a theory strategy that they essentially try to take from industry to industry to industry and essentially try and fit their theories based on the facts or the circumstances of a particular case. So why is that important? It's important because if you face the same lawyers like we do, and the same theories, you essentially know often where the plaintiffs are going to go before they ultimately get there. And many of their theories are frankly perceived by many in the public and certainly by corporate America and corporations outside of America as really not being particularly fair. They're often based on prejudices that they think certain jurors or certain judges may hold. And they're also trying to contort information and data from companies in a way that is hyperbolic, that causes people to try and get angry with companies. But there's some good news here, because if you know where the plaintiffs are going, as I said, it's easier to try and avoid some of these pitfalls. And it's also very important that you identify these cases early on. I mean, to be clear, the sky is not falling. Not every case is a mass tort. Not every time that your company gets sued will you pay $9 billion in punitive damages. However, it's often hard to know which one of those cases, which one of those litigations, which one of those particular venues will cause you that significant pain. So what you need to be doing is identify on the front end the types of warning signals, right? So in other words, is this a case that is going to impact my core product? Is it one case? Is it a case that's going to have a theory that will be able to be expanded to other products? Is this case focusing on an area in my corporation that we see some vulnerability? And if the answers are yes to any of those questions, then those are the cases that you need to ferret out and deal with up front very aggressively, because we've all seen cases where, frankly, there have been hundreds or even thousands of cases where if they had been handled perhaps a little bit differently, you wouldn't have seen that many cases, or perhaps they would have been resolved earlier. But we've also seen cases that have been handled where there's only 1 or 5 or 10 cases that could have been 500 or 5,000 cases. So with that, let me just see if I can give you a bit of an overview on some of the theories and some of the claims that the plaintiffs typically use. So if you were to read a complaint, that's the document that most of you probably know that starts a lawsuit. You would see failure to warn claims, design defect, manufacturing defect. So those are the 3 types of ways that a product can be defective. I'll talk about that in a minute. You'll also typically see fraud, breach of expressed or implied warranty, and consumer fraud cases. And again, the plaintiffs are able to pick and choose and combine these. They don't typically say, well, this is a bow on it, this is just a fraud case, or this is just a warranty case. You'll typically see a laundry list of claims and theories, at least as the lawsuit starts out. So when we talk about a product being defective or a product defect, what is that? And there's typically 3 ways that a product can be defective. It can be a manufacturing defect, right? So there's something wrong with the product as manufactured. There are always going to be litigation, and there will be litigation about manufacturing defects, but that's not really the bulk of what litigation is, because typically both the plaintiffs and the company, the corporate defendant, will usually recognize if there is a manufacturing defect, and those cases can be resolved. And with respect to a design defect, there certainly are, in particular industries, that's the predominant type of defect. In other words, the way you designed your product could have been done differently or better, and there is an alternate design that you should have thought about. And again, in certain industries, that is the primary cause of action. But what we typically see, what most litigation in the states involves, is defective labeling, failure to warn. You knew or should have known that this product could cause injury, either personal injury to your body or economic injury, and you, company, didn't tell us. Had you done that, we would have taken a different pathway. Those are the theories that we typically see. And all of these, of course, have to involve some type of physical harm or property damage, right? Because the fact that your product didn't provide a certain warning or could have been designed better doesn't matter in the air. It only matters if the plaintiffs are able to tie that alleged defect to some type of injury. So what is a warning? A warning may inform the product user of potential risks associated with foreseeable harms or instruct the consumer how to safely use. We're all familiar with warnings in every product, in every different legal system, but this is how it's typically viewed in the U.S. And there is, in almost all jurisdictions in the United States, a duty to provide certain warnings. You have to basically provide adequate warning of risk, known or knowable. things that you actually know or reasonably should have, not things that you never could have anticipated. But of course, you don't have a duty to provide warnings about things that are just obvious. This was a attempt at a little bit of humor. These are actual warnings. You wouldn't expect to have to see a warning on a chainsaw that you shouldn't hold the correct side of it, nor would you expect to have to see a warning on a product that's supposed to put you to sleep, that warning it may cause drowsiness. But again, this is kind of the excesses of our legal system. The one thing also to remember here is that the burden of proof is not on the company. In other words, the company and the defendant don't have to prove that they didn't do anything wrong. The plaintiffs have the burden of proof, and that's very important in our system because in many ways, as you've heard, there's a lot of challenges, and no one's going to tell you it's easy. However, you need to use the tools that we have, and one of them is making sure that the plaintiffs prove their cases. And one of the ways that they will do it, or try to do it, is by focusing on sales and marketing information. Why do they do that? Well, sometimes they do that to overcome the warnings. So in other words, if they're able to show that your warning says don't use the product in this way, but then they can take discovery and they find that you have all kinds of advertising, right, where you're showing people using it in a particular way, or your brochures are showing the product being used in a different way, they will argue that you're undercutting your own warnings and therefore the warnings should not protect you, right? That's one way. The other way is just kind of, good old-fashioned bias. They want to show that, or attempt to show that a company's true motivation is to put profits over, and you could fill in the blank. If it's a pharmaceutical case, it'll be profits over patients. If it's a consumer product case, it'll be profits over consumers. That's a tried and true theory for the plaintiffs that essentially is something that they try and use in virtually every products liability litigation. Now, those of us who kind of live in the real world understand and know that often when people are dealing with marketing and sales issues, the motivations, it's not that people don't care about safety or product usage issues, but there's often brainstorming. It's a different form. It's a different format. The plaintiffs understand that, and they try and take documents, often out of context, in order to create this kind of sense of a company that may not care as much as it should. And again, what I'm trying to do today is to give you an idea of some of the plaintiffs' theories, not to suggest that these are slam dunk winners for the plaintiffs, but just understand what their game book is. This is a case that highlights the point that I raised just a minute ago, this over-promotion point, where a defendant's over-promotion makes it foreseeable that a physician, despite awareness of the risk, would be consciously or subconsciously induced to prescribe the drug when it was not warranted, then the manufacturer may be liable in tort. And we see that this happens to be in a pharmaceutical or medical device case, but we see it in other types of jurisdictions as well. Let me just spend a minute talking about the pharmaceutical and medical device kind of industry, since this topic comes up very, very frequently, particularly in medical devices. As folks may know, there's often a representative from the company who's actually not only selling and assisting the doctor, but often is in the actual the medical room, in the operating room during the procedure to help facilitate the surgery. Those types of situations pose challenges for companies to be aware of, because again, if you have a representative in the in the operating room, again, sometimes it's very necessary, but those are the types of situations that the plaintiffs will attempt to seize upon. And again, another case alleged that defendant sales representatives nullified the warnings that accompanied the medical device. One of the most powerful tools that we have in our kind of defense arsenal are an ability to challenge both general and specific causation. General causation, what does that mean? That's, can the product cause a specific type of injury? Let's just take aspirin and making your ears turn green. Can the aspirin make your ears turn green? That's general causation. Then the specific causation is, if the answer to that is yes, did it specifically cause this particular person's ears to turn green? This is where much of kind of the battleground is, and frankly where we are most successful as defendants. And just to give a recent example, we had a situation involving an SSRI, which is an antidepressant medicine, with well over 700-800 cases. The plaintiffs alleged that particular medicine caused birth defects. And during the course of Daubert hearings in federal court, that's where the court is a gatekeeper, we were able to, without kind of the emotion of a jury, a judge basically determined that the plaintiff's expert was not able to testify about all of these injuries. So what did that do? That limited their ability to bring all of those cases. This is a concept that is probably unique to the U.S. system, and it's a term of art. It's called preemption. And in essence, as you've heard, the U.S. system has two layers. There's a federal layer and there's a state court layer. And each one of them are able, under our system, for the most part, to operate independently. So you can have state court cases, you could have federal court cases. But there are some types of litigations and some areas where the federal courts have, our federal government has determined that they have supremacy. They have the right to make the laws that shall bind essentially everyone, and that's called preemption. And we've highlighted a few of the areas, so if you're involved in any of these litigations or any of these areas, you're probably aware of it, but you should also seek out kind of guidance as to whether a particular theory is preempted, meaning that state law, the typical state law theories can't be brought. They have to abide by the federal legal system. And that often will provide very, very significant benefits to your company. Now, in addition to these personal injury cases, there are statutes. So unlike the common law, which is tort law, there are statutes which are written in virtually every state, which are they're called either consumer protection statutes or consumer fraud statutes. And what the idea there is to try and prevent companies from engaging in unfair or deceptive practices. But as they've come to be interpreted, they're very, very broad, and the plaintiffs often try and use them in ways that were not particularly anticipated. They don't require the same level of causation, the same kind of rigor that's required in some other cases. They also provide for things like attorney's fees. So in our system, as most of you probably know, it's a loser pay system. But there are certain statutes, like certain antitrust statutes and certain consumer protection statutes, where if the plaintiffs are able to prevail, not only can they get damages, but sometimes they can get treble damages, 3 times damages, and often they can recover their attorney's fees. And the danger of these, it's not so much if somebody has a particular product or a one-off type of issue, but what they typically try and do is aggregate these and make them essentially mini class actions so that they can bring lawsuits on perhaps the behalf of 1,000 or 1,000,000 people. I've tried to highlight in the few minutes that I think remain a few other areas where we've seen recently some kind of uptick, if you will, in litigation and claims. And as I said earlier, it's neither a cookie-cutter approach, nor is it a completely novel approach that the plaintiffs employ. They have their theories, they have their game books, they're very skilled, and they try and adapt them to the particular industries. And we've seen a lot in connection with cosmetics as well as the food and beverage industry. And so much so that the FDA has actually gotten involved and issued warning letters to cosmetic companies regarding their label and marketing. And why is that significant? Well, it's significant because when the FDA writes to a company and basically determines that their advertising or their claims are inappropriate or overstates the benefits, it's essentially a pathway to litigation for the plaintiff's bar, because the letters that the FDA writes are very stark and harsh language, and they talk about engaging in kind of deceptive types of practices, engaging in conduct that's, again, if you were to read one of these letters, they would be very striking to you in the tone, and they're essentially form letters. But if a company gets a letter like that, it's posted, it's public, and the plaintiffs will use that, and often it will initiate litigation. So again, it doesn't mean if you get a letter, it's game over. There's certainly ways to deal with it, but it's just something to be aware of in industries that people thought, previously were not as, the same types of rigor might not be applied to some of the statements that they made with respect to advertising and marketing. And I think this will tie into a point I'm going to make in a few minutes, is that the reason why the FDA, I think, is getting more involved is to the extent that there's claims that talk about kind of health or benefits or certain results, they are getting pressure, both from the plaintiffs and perhaps even from some of the other entities that are regulated by the FDA, to make sure that they're a little more rigorous in their claims. But as I said, sometimes the language used by the FDA seems to be very aggressive based on the types of claims that these companies are often making. Now, nuisance claims. Ms. Gay talked about something called, key tam claims, and again, that was a theory that was developed, I believe, 100 years ago, to talk about, it was claims that were supposed to be brought by people, I think it was from the Civil War, when they were defrauding the government. It lay dormant for literally almost a century until plaintiffs kind of reincarnated it, brought it back to life, and a new theory. Nuisance claims have been around for a very long time. And nuisance claims typically have been thought of when, if you have, let's say, a lead manufacturing, a lead smelter next to your house, the smoke would be billowing. Someone would say, that smoke causes a nuisance. It's a problem. It impacts my ability to enjoy my house and my park. But the plaintiffs have taken that theory as of late. Now, fortunately for our side of the litigation, not particularly successfully yet, but they continue to try. So they've taken what was essentially a property damage nuisance claim and applied it to things like alcohol and marketing. They've said, well, various alcohol companies have marketed their products either directly or subversively to youth, and that creates a nuisance. Or in connection with lead paint in old housing, that's creating a nuisance. Same thing with tobacco. It's often with advertising that the tobacco companies, the allegation is, are marketing to children or people under the age of 18. That creates a nuisance. We've also seen it with fast food restaurants. You're marketing products, the plaintiffs say, that causes weight gain or diabetes. Again, that creates a nuisance. That's not the traditional way that when the theory was developed, but again, the plaintiffs are creative. And if these theories gain traction, they could be very, very dangerous. There's one other theory called medical monitoring. And you're probably seeing a theme here. In addition to the specific personal injuries, which in and of themselves, as Ms. Gay talked about, can be very problematic for companies because the damages could be very serious. But what the plaintiffs really try to do is they try to aggregate. Right? They want to basically take what could be a number of claims, all relatively modest amount of damages, but if they can aggregate them and get thousands or even millions of claims, they will get a percentage of the fees and the recovery. It also makes it worth their while to get together and try and aggregate claims. So whether that's nuisance claims, consumer fraud claims, or medical monitoring claims, it's all the same. And medical monitoring is a theory essentially where the plaintiffs try to get compensation, try and get recovery when they haven't presently sustained an injury, right? So the kind of the example that people typically might think of is if you were exposed to a particular toxin and the injury may not manifest for some period of time, you should get some type of monitoring to determine if you will ultimately get it. And in some areas, that's a perfectly appropriate theory. It's just often when these theories are stretched beyond what they're intended that it becomes very problematic. So there are a few areas where we tried to, put our thinking caps on and look into our crystal balls and find out where some of these theories might go. And, we're all seeing a lot of press and great development with respect to areas like drones, but this is certainly an area that one could at least envision certain claims, not that they will have merit, not that they will win, but certainly where, anyone involved with this needs to be thinking about what the plaintiffs are thinking about, which is areas to target. And again, could there be design issues, the interface, the lost link issue, GPS geofencing? Could there be nuisance claims or invasion of privacy or unfair and deceptive acts claims as a result of perhaps a drone particularly in a city area? Another area is driverless cars. Again, we've all probably just watching the press and hearing, and they sound fascinating and interesting, and probably will be here before we know it. But as these industries and technologies develop, or technologies like them, there are certainly going to raise challenges for manufacturers in terms of potential product liability issues. And the way to deal with those, of course, is to be prepared for them and to think them through before you're ultimately in the situation where they can cause discomfort for your company. Now, do I have a few minutes left?
はい、ございます。Please continue.
Thank you. I wanted to talk about, just briefly, one or two other cases, but the reason why I asked if I had a little more time was because we had received a few questions prior to this seminar, which I thought were excellent questions, and I was just going to maybe take a few minutes even before the question and answer period to just see if I can address them, because I thought that they were actually not only very good questions, but applicable to many of the things that you've heard from myself and my colleagues today, and I'd maybe take your indulgence to respond to those. This is just a case that I think highlights this issue with the FDA as well, beyond the cosmetics point. So there was a product that was a DNA testing device, and there was a complaint that the defendant claimed the results would help users plan for the future and mitigate serious diseases. And what the FDA did was they sent a warning letter and said, this essentially went into the realm, into the space that this product should have been regulated, and it required the company to cease its advertising and marketing efforts. And what we've seen is similar types of efforts. We've all seen, without getting specific, whether they be watches or certain products that measure how many steps we take a day, right? Or what our heart rates are, or have GPS. And all of these are areas where the FDA in particular is taking a close look. And from my kind of vantage point, where I think the lines are being drawn, at least currently by the FDA, is if it's just a monitoring, if it's just telling you that you walked up 10,000 steps today, or your heart rate maximum was X, Y, or Z, that's fine, right? That's what the FDA has told us. But if you're going to get into something where it's diagnostic, where you're going to try and tell people what kind of their blood pressure is, what their glucose levels are, or even use some of the other data in a way that falls closer to the realm of medical diagnostic, then I think that's an area you need to look very closely. And as you can imagine, probably just as you're thinking through these issues, they're not always very clear lines. Sometimes they are, sometimes they're not. So again, if you're involved in industries that are kind of at the forefront, which many of these are, really, of these types of technologies, these are the types of things that you know, I think you need to be thinking through and essentially putting on, you know, your collective thinking caps in order to determine what the plaintiff's perhaps best theories are, and then figuring out, are they right, or what our answers were, and that's really going to be, you know, your best defense. So let me just, I think in the few minutes that I have, read one or two of these very good questions. So one of them deals with product liability, and it says, when the product liability law took effect in Japan around 1995, critics said the United States product liability law was abusive and a PL, product liability, hell. What is the current situation and view? Well, I think we've covered some of that, but what I would say is this, is that there is really no one-size-fits-all approach to products liability or mass torts in the United States. You've heard from Ms. Gay and from Mr. Goldstein that certainly as a general rule, federal courts are better. You've also seen the tides change. If we were having this conversation probably 5 or 7 years ago, we would have said Texas was a place that was particularly difficult, at least in terms of products liability, for corporate defendants. Well, Texas has a new statute that essentially changes the rules. So these kind of theories continue to change and continue to move, often based on, frankly, pressure from citizens, from companies in these particular jurisdictions who eventually say, you know, we don't want our jurisdictions to be business unfriendly, so often the rules will change. Another question is, how do you position yourself to settle a case early? I think, again, great question. And, you know, to me, the answer is, again, you have to know where the plaintiffs are going. And, you know, in a few words, where the plaintiffs are going to go is to try and get inside your company, try and mischaracterize and misstate often the issues. So the way that you need to prepare yourself or prepare your company to settle early is to neither be overly aggressive in discovery or to be conciliatory. But the way I look at it is you have to be transparently aggressive. So what that means is that you have to be aggressive, but you have to be straightforward and forthright about what you're doing, and, you know, and get a court, if necessary, to sign off, and prepare from day one as if you were going to trial. You have to look at every single case and prepare as if you're going to trial. And if you do that, the plaintiffs will understand that you are serious, your company is serious, and that is the best way to settle a case both early or get a case dismissed or settle it with a positive resolution. Because again, if the plaintiffs think that you're unsure and you're going to do this for a year and do it half-heartedly, they will read that very quickly, and that's the last way that you would want to settle a case early. And let me just, one final question. This is on class settlements. Actually, it's a few questions. How frequently does the court reject the proposed settlement and have the parties renegotiate the terms? What generally drives a court to reject a proposed settlement? And any examples where a court did not accept the settlement? So again, all very good questions. If we were speaking to you probably a decade ago, the answer would be it's very, very 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 rare for a court to second guess a class action settlement that the parties have presented. And they would adopt pretty much the terms, and they would allow coupon settlements and very other avenues of settlement. It's still certainly an avenue to resolve cases and very effective, but courts are much more involved in the settlement process, particularly with class actions, than they ever were. And some of the criteria that they look at are they compare what they think the plaintiff's lawyers, because they understand, not all, but many of the cases are plaintiff lawyer driven, they look at what the legal fees are, and they compare that to what they think the actual class members, the folks who allege that they were injured, are going to get. So that's first and foremost. And they will often, if they don't see that there's enough compensation going to the class, but most of it's going to the plaintiff's lawyers, they will reject the class. And they will often essentially send the parties back to the drawing board to have what they believe is a more equitable distribution of the claims. And I think that an example comes to mind, and unfortunately, Sheila Birnbaum, who was ill and unable to be with us, was involved in representing the NFL, the National Football League, and those of you may have read in the press that there was claims about concussions, and that was a situation where there was a proposed settlement, and the judge at that point determined that for a number of reasons she was going to send the parties back to the drawing board to change some of the terms, which they did, and then ultimately approved it. So that's a kind of a real-world recent example. So with that, I very much thank you all for your attention and your very good questions, and appreciate the opportunity to speak with you today.